Referendum, the 39th Amendment to the Irish Constitution, and the upcoming referendum on the 8th of March, International Women's Day 2024, is a three-pronged approach to change the fundamental principles of natural law in the Irish Constitution. Irish Neutrality Bill, the Right to Housing Bill, and the family within the home, and the mothers and the woman within the home, 2022, all in the final stages. So what I want to say here is, people, you're in the same situation and scenario as a turkey voting for Christmas. Vote nil, no, 8th of March, International Women's Day 2024. There you go, 39th Amendment of the Constitution, Right to Housing Bill 2020. 39th Amendment to the Constitution on Neutrality Bill 2022. And the family, Article 41, durable relationships. That's what they want. Durable relationships. Without her life within the home, true social order cannot be obtained. Therefore, the state guarantees to protect her life within the home. Article 40 to 44 is your inalienable, indefeasible, imprescriptible, and sovereign rights, antecedent and superior to all positive law. Natural law is enshrined, codified, and enrolled in the office of the Registrar in the Irish Supreme Court. Personal rights, Article 40. The family, Article 41. Education, Article 42. Private property, Article 43. Religion, Article 44. All under scrutiny by the Government of Ireland and the European Union. It's called the 39th Amendment. Our sovereign neutrality is under attack. It's a three-pronged approach. It's unconstitutional, it's repugnant, it's ultra vires, and in violation of the Human Rights Convention and the Irish Constitution. Durable relationships. Rights of residence derived from durable relationship with an EU citizen are left to a relatively wide discretion of the member states, pursuant to Article 2.2b, Directive 2004/38/EC Directive. The partner with whom the Union citizen has contracted a registered partnership on the basis of legislation of a member state, if the legislation or the host member state treats registered partnerships as equivalent to marriage and in accordance with the conditions laid down in relevant legislation of host member states, qualifies as a family member provided they have a durable relationship duly attested with an EU citizen pursuant to Article 3.2b. Unregistered partners are well beneficiaries of the directive. The durable relationship was expressly excluded from the scope of Article 2.2b. Unlike the amended proposal, it does not cover the de facto durable relationship EU Commission document 52003 SC 1293. Article 3.2a covers other family members. No restrictions as to the degree of relatedness No restrictions to the degree of relatedness. I hope this is ringing alarm bells. If material support is provided by the EU citizen or by his partner, or whereas serious health grounds strictly require the personal care of a family member by the Union citizen, pursuant to Article 3.2, other family members and unregistered partners can attest a durable relationship must be facilitated entry and residence in accordance to be a host member state's national legislation in the light of Preamble 6 Directive. The situation of the persons who are not included in the definition of family members must be considered in order to maintain the unity of the family in a broader sense. The questions discussed in this paper are the following. Are member states genuinely considering the concept of durable relationship in view of maintaining the unity of the family in a broader sense? And 2. How to overcome legal uncertainty and which criteria, both at EU and international level, can be taken into account in order to assess whether a durable relationship is genuine and should be granted the rights set forth by the directive. Who qualifies as durable partner on the EU settlement scheme? Some parts of the rules relating to the EU settlement scheme are so difficult to comprehend that it is at least arguable that they lack clarity of law. An aspect of the definition durable partner contained in Annex 1 of Appendix EU definitions is one such example. Under Tribunal Judge Canavan, those were the words the Upper Tribunal Judge Canavan trying to decipher the definition of durable partner under the EU settlement scheme. This post is my best attempt at simplifying increasingly convoluted definitions. What does durable partner mean anyway? Durable partners are those couples who are not married or in civil partnerships, but who are nonetheless in commitment relationship under other parts of immigration rules. The requirements are quite strict. Unmarried partners must show that they have been living together for 2 years in a relationship akin to marriage to qualify. The rules for durable partners under the EU settlement scheme are a bit more flexible. Starting point, and the easiest way for a couple to show that they have a durable partners is still to have lived together for 2 years. However, the scheme also allows applicants to show other significant evidence of durable relationship. The Home Office guidance is very helpful in terms of what is generally accepted as other significant evidence of durable relationships, including but not limited to evidence of joint responsibility for a child and evidence shared financial responsibility. The guidance also confirms that the couple does not need to be living together at all. Couples may have lived apart because one member is studying or working elsewhere, because of religious or cultural norms, or because they are the same-sex couple from a country who would not tolerate them living together. In those cases, the Home Office would still expect to see evidence of a committed relationship such as evidence of visits to see, etc. Ultimately, although there is some flexibility around the need to have cohabited and the length of the cohabitation, the Home Office would only accept as durable relationships which is shown to be serious committed. They must accept that they are genuine and realistic likelihood of the relationship continuing long term. Two 18-year-olds have just met who live in a respective parents are unlikely to meet the definition as much as they may swear eternal love. But contrast to two 30-year-olds with a baby likely to meet the definition even though they may have moved together recently. Upper Tribunal, so this is cases 24th of January 2023, 31st of March 2023, 19th of January 2023. They're trying to change what it is to be a durable relationship, that you don't need to be married. And once that happens, floodgates open, because anybody can be in a durable relationship, and it is not limited to the amount of people who can be in durable relationships, and children in those durable relationships, and relatives and in-laws, etc., etc. Upper Tribunal fails to understand the meaning of durable relationship. United Kingdom Statement of Changes to the Immigration Route, Statement of Changes to UK Immigration announced. NHS, what is a durable partner? A durable partner, you've been in a relationship for at least 2 years, or who lives with you, or is someone you have a child with. You and your durable partner must intend to live together permanently, not be blood relatives. Any other type of relationships or previous marriage that you or your partner have had must have permanently broken down. You can add a durable partner if they're not a UK citizen and meet some other conditions about the nationality or residence. If their nationality of the EU, Switzerland, Norway, Iceland and Liechtenstein, they can be added if they arrived in UK after 31st of December 2020. Your relationship began on or before 31st of December 2020. If your partner arrived in the UK before the 31st of December 2020, they must make their own applications if they're entitled to a card themselves. If they're a national of another country, these conditions also apply unless they have settled or pre-settled status under European Union Settlement Scheme EUSS, in which case we will just have to verify their residency. What is Article 45? Worker freedom of movement of workers. Article 45 of the TFEU permits EU workers to move freely within the EU. It prohibits any discrimination on the basis of nationality in regards of the conditions of work, employment, as such remuneration. Article 47 of the Charter of Fundamental Rights. All persons have the right to obtain effective protection from the judges and the courts in the exercise their rights and legitimate interests, and in no case there may be a lack of defence. What is Article 45 of the Schengen or whatever agreement? Every citizen of the Union has the right to remove and reside freely within the territory of a member states. 2. Freedom of movement and residence may be granted in accordance with the treaties to nationals of third countries legally reside in the territory of member states. Freedom of movement for workers shall be secured within the Union. 2. Such freedoms of movement shall entail the abolition of the discrimination based on nationality between workers and member states as regard employment, remuneration, and other conditions of work and employment. Article 45 of the Charter of Fundamental Rights of the European Union. The Charter also provides freedom of movement and residence. Freedom of movement entails right to exit and enter member states with valid identity card or passport. And here we have Roderick O'Gorman. Progressive organisations must explain any decisions not to support the referendum. So, it's coercion and railroading. Rejection of proposed changes would leave status quo on woman's place within the home. You know, this is a man talking about women within the home. It's quite ironic. A gay man without any children, and he's talking about women and family, you know. So, durable relationships. The legal concept durable relationship is to be found in the European Union (EU) law regarding the rights of EU citizens and their family members to move and reside freely within the EU. This language has not previously been recommended by citizens' assemblies or at the committee. Freedom of movement and residence constitutes one of the fundamental freedoms of the EU. This right is enshrined in Article 45 of the Charter of Fundamental Rights. Just after reading bits of it, the Charter, this right is conferred directly on every EU citizen by Article 21 of the Treaty of the Functions of the European Union, TFEU. Excuse me. Directive 2004/38/EC on the right of the citizen of the Union of the family members to move and reside freely within the territory of member states. OJL/158, the Citizens Directive, aims to, inter alia, among other things, codify community standards to simplify and strengthen the right of free movement and residence of all EU citizens, and to also grant to their family members, irrespective of nationality, the right to reside with them. The right of the family members to enter and reside in a member state is not an automatic one. The decision whether entry or residence could be granted in such persons is examined by the host member state on the basis of its own national legislation, i.e. the Constitution, taking into consideration matters including persons' relationship with the Union citizen. The Citizens Directive was transposed into law by the European Community's Free Movement of Persons Regulations 2015 regulations and entered into force on February 2016. Think very much about the upcoming referendum, people, and vote no, because this is all about freedom of movement. There is more sinister things at play here, and the right to private property and your neutrality. It's a three-pronged approach, as I've just read out. It's all there for you, and that's what's happening on the 8th of March. So, don't get caught with your knickers around your ankles and vote no.